This scene shows an employer giving his supervisor their monthly wages. However, it is lower than the actual salary that is stated in their contract.
Assalamualaikum bos.
Waalaikumsalam.
Can I see you?
Yes. Why Aiman?
Boss, I want to tell you about the salary that I get and my coworker gets. Why we only get 1,500 only? Boss not already about the strike first line. So I think boss know why I came today. Therefore is are extremely upset about the sudden pay cut. You promised 1,800, but you pay me and my coworker only 1,900 without explanation.
I apologize, but the company can be it is highly punishing. I had to make a budget reduction across the company.
But you cannot simply reduce pay by 70% without notice. We have the right to work to what was agreed upon.
Unfortunately, the situation is I cannot afford the original salaries. My hands are tied. I hope you understand.
Then I will have no choice. But I want to seek system protect union. This misstatement cannot stand. Legal is legal. The boss cannot whatever what the boss want. Right?
The supervisor met with the employer to voice out his and his co-workers' concerns about the deduction of their wages without notice.
Yes, Aiman.
I'm Syakirah, representing the union. So what's the issue?
My issue is my employer was very much in the weekend. Yes.
So you need to meet your agreement.
You right now?
Okay.
Let's Who is this?
This is my lawyer, contact union. So you can talk to my lawyer about my issue. You can see?
So as we understand it, you are actually cut salaries by 70% despite a prior agreement on 1.8 amount.
It was necessary on financial health of the company post-COVID. I had no choice.
But under the Employment Act 2022, that was enforced on January 2023, you cannot simply reduce salary. You cannot simply reduce a contractual pay without agreement.
This situation was urgent. I had to make quick decision. I hope you understand.
Be right as it may, you violate your worker right under Malaysian law. We advise you to return exact amount to your employer.
Impossible. I cannot afford. Right now, I will give in.
Then I believe you must take this to industrial court for formal dispute resolution. Your employee's right will clearly violate.
So now, you can get out in my office. Now!
Really? What? Sini Pak.
The
The supervisor finds a lawyer to advise on his issue, and they later meet with the employer to discuss about the issue, but the employer refused to compromise.
Complainant previously employees in company defendant as a supervisor claimed against the defendant for unfair salary. The complainant was a full-time worker, which is protected under the Employment Act Amendment 2022. Defendant could get penalty as they are violate the law. All the employees should get 1,800 ringgit Malaysia as it was the minimal requirement under the Employment Act. Under Section 24, Subsection 1, Employment Act 2022, no deduction shall be made by an employer from the wages of an employee otherwise than in accordance with this Act.
Under the terms and conditions of contract of employment, it is stated that discretionary matters give the right of choice for employer whether to give certain benefits.
Managerial prerogative is the concept of the right of managers to control and direct the work process, unhindered by interference from employees, trade unions, or the law.
As you know, economy post-COVID affect the company business. So I have the right to specifically state whether there is deduction or not.
Section 24, Subsection 3A, deduction in respect of the payment to a registered trade union or cooperative thrift and a loan society of any sum of money due to the trade union or society by the employee. Furthermore, complainant also protected under the employee under the contract of service as the complainant was a full-time worker. Employment Act 1955 Amendment 2022 protect any employee hired under a contract of service. The employer cannot change the terms and conditions of employment unless the employee agrees to it. Any terms and conditions of employment in a contract of service that is less favorable than the relevant provision under the Employment Act is null, void and illegal. I have reviewed the evidence and also the arguments. I hereby order the employer to reinstate full salaries as per prior agreements.
But the business cannot afford this.
Ignorance of the law does not excuse violation. My ruling stands.
This scene shows the argument between the employer and the representative of the trade union in industrial court. At the end, judge ruled that the employer needs to pay the exact amount of the salary.
Trade union in Malaysia function as an organization that fight for the right of workers in the various matters, especially those related to the welfare of workers. It was the main function of this union from the beginning of its establishment in the 18th century until the formation of the Trade Union Act of 1959 and the Industrial Relations Act of 1967. The formation of this act is proof that this union will guarantee the well-being of workers' life as a party that contribute energy from the physical and mental aspect of the employer. In general, trade union membership in numbers of people. Trade union is how to effectively is involved in social dialogue with government employees. It is the proposal that workers serve in the community. As employees working for an employer, they should consider various there are various advantages that can be obtained by the employee. Among the advantages that can be obtained are being able to protect their rights as workers, being able to fight for equal rights, being able to guarantee a safer workplace, and being able to obtain support and solidarity in solving issues.